Ladies and gentlemen of the nation, citizens watching from afar and close alike, lend me your attention. Today I stand before you not to dramatize the law, nor to offer easy conclusions, but to bring forward a moment of tension, of accountability, of duty questioned and truth pursued. Because in the heart of the courtroom, beneath the glare of cross-examination and the throb of public expectation, one man sat. A former detective, a former leader, a man now under the microscope, not just for what he did, but perhaps more damningly, for what he didn't do. His name is Mr. Bignell, once tasked with the pursuit of justice. Once in charge of an investigation that demanded urgency, clarity, precision. And yet, when pressed by the defense, pressed by the counsel, pressed by the weight of duty, it all began to unravel. Defense barrister David Campbell SC stood tall, his voice firm, his intent clear. He suggested, without hesitation, that Mr. Bignell had shown disregard for obligation, disregard for the very fabric of the court's dignity. He stared the former officer down and asked plainly, "You defied that order, didn't you?" And with little hesitation, Mr. Bignell replied, "I did, yes." He added quickly, perhaps to cushion the blow, "It certainly was not my intention to be disrespectful." But is intention enough when the duty is neglected? When court orders are brushed aside? When the search for justice is stalled by excuses and explanations? Mr. Bignell offered his rationale. He had been unwell. He had considered getting a medical certificate. But in the end, he chose not to follow through. He simply returned to court when it suited him. Mr. Campbell wasn't satisfied. He sharpened the knife of questioning, accusing the former detective of choosing convenience over obligation. He laid bare the charge that Mr. Bignell believed he could choose when justice mattered. That he answered to his own schedule, not the system's. "This is part of you, isn't it, that you do what you want to do, rather than what you should, Mr. Campbell said. "Absolutely not," came the reply. But doubt lingered like smoke after fire. The defense dug deeper. They didn't just question Mr. Bignell's attendance, they questioned his method, his priorities, his fundamental fitness to lead an investigation that carried the weight of human pain and alleged harm. Because at the core of this trial lies a serious allegation. And a man who once led the charge to uncover truth is now being accused of letting that truth slip through the cracks. At one point, Mr. Bignell admitted he once told police he was happy to get arrested. A stunning line, one he would later describe as an off-the-cuff comment. But in court, off-the-cuff rarely suffices. Every word becomes a brick in the wall of perception. Mr. Bignell had led the investigation into serious allegations from May 2021 until his resignation from New South Wales Police in 2024. He was not called by the defense, but by the Crown. A witness for the prosecution. Yet what followed resembled an inquisition. He described his process, reviewing statements, collecting witness accounts, conducting walkthroughs in Sydney's CBD to test the claims of one of the complainants. But when the defense took over, they tore into the timeline. They examined what wasn't done, what could have been done earlier, what should have been pursued with greater urgency. Because one glaring omission stood out, the failure to interview a third man. A man who lived in the very apartment where the alleged 2015 assault occurred. A man who might have held the key to verifying, or challenging, the story at the heart of this trial. Mr. Campbell zeroed in. It would be rather central to determine whether the flatmate was in the lounge room, he said. "I agree, Mr. Bignell replied, his tone subdued. "You can't give us one reason why you didn't task anyone to make that inquiry." Came the next thrust. "I cannot," the former officer admitted. It was a moment of silence. A moment when absence screamed louder than presence. But that wasn't all. There was the issue of the taxi records. The younger complainant said Mr. Ward had paid for his ride home to Maru Meadow. A small detail, but one with the power to verify memory, confirm presence, support narrative. And yet, police didn't request those records until 2024. 3 years after the investigation began. By then, the taxi company had changed hands. The records were gone. The trail had gone cold. The evidence vanished like mist in morning sun. That was an unfortunate development, yes, Mr. Bignell conceded. And when asked why he hadn't spoken to Mr. Ward's regular driver, a potential witness who might have confirmed a pattern, or explained a night, he admitted that he hadn't. He had simply relied on the complainant's version of events. This isn't a story of overt malice. It's a story of hesitation, a delayed action, of evidence unpursued, of questions left hanging in the still air of the courtroom. It's about what happens when those we trust to seek truth fail to act with urgency. When key decisions are postponed. When investigation becomes inertia. The courtroom is not a place for shortcuts. It is where lives are scrutinized, actions are dissected, and the weight of human testimony is placed against the scale of justice. And here was a former officer, once entrusted with leading that very process, struggling to justify the gaps. He wasn't on trial, but he was under judgment. Because when you wear the badge, when you carry the notebook, when you lead the case, your every action matters. Your inaction matters even more. The defense didn't just want to challenge Mr. Bignell's conduct, they wanted to expose a pattern, a mindset, an approach that, in their words, revealed someone who does what he wants to do, rather than what he should. And while Mr. Bignell pushed back, the admissions kept coming. That he defied a court order. That he failed to interview a key witness. That he missed the chance to obtain time-sensitive evidence. That he relied on accounts instead of verifying them. These are not trivial oversights. These are the cracks that erode public confidence. These are the lapses that lead to trials built on missing bricks. In a world that demands accountability, justice cannot afford delay, nor excuse, nor reliance on convenience. Mr. Bignell's testimony has become more than a recounting, it has become a mirror. A reflection of how fragile justice becomes when diligence fades. And now, as this trial marches forward, the echoes of what wasn't done might matter just as much as the words spoken in sworn testimony. For in that courtroom, truth competes not only with lies, but with silence, with delay, with absence. And the question remains, who will answer for